Hariom friends, welcome to the second part of the series on the Waqf issue, particularly the Waqf Act. And like I promised in the first part, in this part we will look at the historical development of the Waqf Act in India and how it came to have the present shape and form, and how gradually over time it grew into this Godzilla-like monster, which has got tremendous powers, in fact, more powers than the judiciary itself. So let's hop on to the slides. So during the Islamic rule in India, Waqf was pretty much centralized, and my knowledge on that topic is very sparse. But there's a very good article by a professor, which I link in the description box, which talks about the development of the Waqf Act, how it was during the Mughal times, and how it kind of evolved into what it is today. So in the Mughal times, it was pretty much centralized. I believe there was a office called Sadr or something similar, and all the Waqf assets were controlled by the government. And obviously, during the Delhi Sultanate and later Mughal times, and even the Deccan Sultanates, so wherever Islamic rule was there in India, a lot of this was simply land grab and grab of properties of Hindu temples, the temples themselves, which are demolished and mosques were built in their place. So most of this was Hindu land. And this image is actually from Jaunpur. I think it's the Atala Devi Masjid. Uh, Atala Masjid, not Atala Devi. This was a Devi Mandir, which was destroyed by the Sultans of Jaunpur in Uttar Pradesh, and a mosque was built over it. So let's move on to the British times, which is when the Waqf as it exists in the present form started to develop. So the first attempts of the British were by their nationalized company, the East India Company, and they had two regulations. One was called the Bengal Code Regulation of 1810, and after a few years, in 1817, they had the Madras Code of Regulation. So these were the first British attempts to assert control over primarily Hindu temples, Hindu charitable trusts, Hindu assets, and obviously by conjunction, the Muslim religious structures such as mosques, etc., were also brought into their purview. So this was more of getting control and getting control over the revenues of the temples, because the temples typically had a lot of land and villages associated with them, which used to support the temple, and the temple used to carry out a lot of activities like running schools, hospitals, charitable trusts, etc. So the East India Company wanted to get its claws into that money. So these were the first two regulations. So for a long time, till 1857, there wasn't much activity, because after the 1830s, there was very frenetic missionary activity in India, which was encouraged by the British. And this aimed to convert both Hindus and Muslims to Christianity. So even the Sipahis or Sepoys of the East India Company were forced to listen to Bible lessons on Sunday, were forced to stand in the heat and listen to these sermons by padris and so on. So one of the key reasons for 1857 was this kind of Christianity being forced down everybody's throats. So post 1857, what the British did was they started to loosen their claws from religious institutions, and the Religious Endowments Act of 1863 was a step in that direction. So it brought to an end a control of government and introduced management by local committees. Now, further development was the Charitable Endowments Act of 1890, which applied to both religious and non-religious charitable institutions. So the key purpose was to oversee management and administration. But from the 1880s, another change happened, which was that the British realized that the Muslims were a key constituency who would form a formidable prop for their rule in India. So if they set up the Muslims against the Hindus, so they had used this strategy when they were fighting the Marathas and other Hindu powers. So they would typically prop up the Nizam or some other Nawab or ruler against the Hindus, just as a useful irritant, which would divert the Hindu attention. But 1857, so there was severe retribution against the Hindus, but there was retribution against the Muslims as well. Now, Syed Ahmad Khan, who was given the title of Sir and who was the founder of the Aligarh Muslim University, was one of the key movers and shakers who convinced the British that the Muslims were actually a loyal prop and they had nothing to kind of do with the Hindus. So From the early 1900s, the British started to bring in legislation to cater to Muslim demands for laws which allowed them to govern their own assets. And as I said before, they were aiming to appease the Muslims and building a bulwark against Hindu resurgence. So Waqf was started to be recognized as a legal concept from the 1910 onwards, and one of the first acts or the laws which recognized Waqf as a valid legal concept, till that point it had no legal standing, was the Musalman Waqf Validating Act of 1913. So this legalized Waqf alal Aulad, which means the family Waqf. So by recognizing that a Waqf could be not created for both the benefit of the family and for charitable purposes. And this act helped to protect Waqf properties from inheritance disputes and application of colonial property laws, which did not recognize Waqf. And one of the key reasons for bringing in this act was there was a lot of pushback against one of the judgments by the British courts in India against a Waqf dispute, because the property laws of the British simply did not recognize the Waqf concept. So this was again pandering to the Muslim, vocal minority kind of thing. Now, this kind of led to the situation where once you let the hounds out of their cages, how do you control them? So there was a lot of corruption in these family waqfs, mismanagement, property disputes, and within a decade, the Musalman Waqf Act of 1923 was brought in to try and reduce the corruption and mismanagement in the waqfs. So till this point, waqfs were not required to maintain any accounts, no accountability. So this was kind of uh, required the waqfs to maintain accounts. And from the 1930s onwards, you had waqf legislation and the formation of waqf boards in almost all the presidencies and princely states such as Hyderabad, which had primarily Muslim rule. So you can see that within 30 years, waqf was established as a legal concept, and the Muslims had already started to get their own set of laws. And the final milestone before transfer of power in 1947 was the establishment of the Delhi Waqf Board in 1943. So more and more powers were given to the Islamic rulers. Sorry, not Islamic rulers, and to the Muslim community in general. Okay, so we'll move on to the next slide. So post 1947 was really when the action started as far as the Waqf Act was concerned. So we have seen that till this point, Waqf was now firmly established as a kind of a legal instrument in India. And this was in the euphemistic rubric of Muslim law, which itself is an irony in a so-called secular country. And the Congress governments carried this forward by enacting the Waqf Act of 1954 to manage Waqf properties. So what the 1954 Act essentially did was created a mini Pakistan within India, and it created this mutant Godzilla called the Waqf Board. Now the Waqf boards were already set up, but they did not have these enormous powers which the 1954 Act gave them, and it gave them enormous judicial and executive powers. So first thing was this Waqf Board in any state or region was all Muslim. So you recognize Islamic concept of kafirs being separate or non-Muslims being separate. So no non-Muslims, only Muslims. And it was the sole arbiter of all Waqf properties across India. So it became the key arbiter of prime real estate in India. And in one shot, it got its hands on this enormous property base within India. And Professor Surajyoti Gupta has written an excellent article on the Waqf board, which as I mentioned before, I link it in the description. And she mentions, or she comments, that the centralization and pooling together of Waqf resources concentrated enormous wealth in the hands of the community, and this is not available to any other community. So typically Hindus and others, which is why everybody wants to be declared a minority, from Sikhs, Jains. Um, I believe the rate at which the caste politics are going on in India, I'm sure Brahmins will also ask to be considered a minority within the next 5 or 10 years. And again, there was this usual story of mismanagement, illegal sale of Waqf properties, and so on and so forth. And what the 1995 amendment to the 1954 Act did was, after partition, a lot of Hindus and Sikhs who had been driven out from Pakistan settled in Delhi and other regions, and they occupied properties, or they settled into properties which had been abandoned by the Muslims who had migrated to Pakistan. Now, all the Hindu property in Pakistan and Bangladesh was taken over by Muslims or the government. Whereas in India, by the amendment of 1995, the Hindus and Sikhs had to evacuate these properties. So they had been settled, they had been homeless, they had settled in these properties for decades, and now the Waqf board asserted complete control over these properties. So evacuee property, as it was known, was again brought under the rubric or the control of the Waqf board. So typical injustice on Hindus and Sikhs. But the usual, after 1954, the usual story of mismanagement, illegal sale of Waqf properties, corruption led to a series of amendments. There was one in 1969, and in 1976, the problem grew so huge that the government of India established a Waqf inquiry committee to examine, what was going wrong. And based on the recommendations of the Waqf inquiry committee, there was a 1984 amendment to the Waqf Act, which was a minor amendment. There were only two amendments accepted. One was the increasing the limitation of filing suits in respect of Waqf properties from 12 years to 30 years. So the Waqf board could say that somebody's grabbed these lands, and previously you had 12 years to dispute this, or the Waqf board had 12 years to dispute this, whereas after the 1984 amendment, they had 30 years. So the time period kind of went on. And the 1984 amendment, sorry, I stand corrected, so it was 1984, not the 1995, which applied the provisions of the 1954 Waqf Act to the evacuee properties. So these were properties which are abandoned by Muslims during partition. This led the Waqf board to evict Hindu Sikh refugees who had settled in the property abandoned by Muslims during partition. So this was almost after 30-35 years that Hindus and Sikhs were being kicked out of their homes again. And this happened in independent India. So in 1995, the Waqf Act of 84 was given a quiet burial. And this was when, the Waqf really got its Godzilla-like powers. So sweeping powers were given to the Waqf boards to declare any property arbitrarily as Waqf. And coming to 2006, you had the notorious Rajendra Sachar Committee report, which essentially recommended reservation for Muslims in all armed forces, executive, judicial services, pretty much everywhere. And one of the recommendations of the Sachar Committee was to give more powers to the Waqf for community well-being. So what this means is all the wealth and resources are concentrated in Muslim hands and without government control, and they can use it for the benefit of the community, whereas Hindus never had any such benefit or advantage given to them by the government. On the contrary, Hindu temples are controlled by endowment boards, which are government departments, and there's massive corruption, and these funds are diverted to these Hajj trips and so on and so forth. And there's also the Jerusalem trips, which have started in the last few years. So the 2013 was again a more toxic and mutated version of the 1995 Act. So this brings us to 2025, where the government has kind of sought to course correct and has brought in several amendments to the fast mutating Waqf Act. But the important point is even the 2025 Act, I'll go into this in more detail, does not cover private property. So if Waqf board lays claim to your house, your land, you need to fight it out. It only protects government property from, the depredations of the Waqf boards. And key thing we should have done, and Advocate Vishnu Jain has correctly pointed this out, this act is illegal and it should have been scrapped. And the fact that this is kind of being continued even by the so-called Hindu nationalist BJP government indicates that India is essentially kind of a quasi-Islamic country with a secular mask, which is why Hindus are discriminated against. There's a pretty much apartheid system against Hindu culture. society, family structure, pretty much everything. So this is it for this time, and thank you for watching. In the next episode, we'll cover what is known as Waqf by user, which is nothing but land grab under the Waqf burqa. So thank you for watching. Please remember to share, subscribe, and like this video. And I will see you next time. Hari Om.